welcome to Understanding Immigration Compliance, I-9s, Audits, and ICE raids. My name is Audry Thompson. I'm a staff attorney here with the Penn State Center for Agricultural and Shale Law. The Understanding Ag Law series is an educational course designed to provide subject matter literacy and competence on fundamental issues of agricultural law to attorneys and business advisors who work with or represent ag or rural clients, but who may not necessarily specialize in agricultural law. The Ag Business Development Center, this series is sponsored by the Ag Business Development Center and Pennsylvania Department of Ag, established with the 2019 Pennsylvania Farm Bill. This development center aims to enhance the long-term vitality of Pennsylvania farms by supporting farm transitions, both from generation to generation and from conventional to organic, supporting beginning farmers, providing risk management education, and providing financial assistance through grants and low-interest loans. We've covered numerous topics so far. You can check them out on our landing page right there, ag labor, conservation programs, all kinds of stuff. We encourage you to mark your calendars and register for our upcoming programs. In November 21st, we've got cell cultured foods and labeling laws. Then in December, on the 12th there, we'll do Clean Water Act and ag biosolids and food processing waste cleaning application. And then in January 2026, we'll talk about Pennsylvania seasonal farm labor law. Those are all at noon. They are all on Fridays, and Attorney CLE is available for all of them. We also have our quarterly dairy legal webinar series. Our next webinar under that program will be January 20th. That will also be at noon Eastern Time, and PA Attorney CLE will also be available for that. We're excited to announce that we've teamed up with Penn State Extension to offer education and services through the AgWorks program, which is funded 100% with federal funds from the U.S. Department of Labor, with a grant totaling $1.3 million and 0% non-federal funds. This program aims to link agribusinesses to workforce services, educate workforce professionals about the needs of agribusinesses, provide services and training to individual agribusiness based on needs, and help small agribusinesses grow and succeed. This program will also register 1,000 agribusinesses with the PA Career Link online system. Under this program, the Center for Ag and Shale Law will present 20+ employment law programs geared for non-attorney producers and business owners, and provide legal consulting to program participants. Upcoming for that, on Tuesday, November 18th, we've got I-9 and ICE raids, kind of a replication of this program here, but this program is going to be very, very good. We'll also do anti-discrimination law compliance on December 16th. If you're watching this and you know a PA farm that would benefit from this program, or you are a PA farm that would benefit from this program, please visit the website, share the contact info, take and share our survey, and refer ag businesses or questions to agworks@psu.edu. And then finally, just a few reminders before I turn this webinar over. We are recording this. If you have any questions, write them in the Q&A feature and I will collect them and ask them at the end. We encourage you to fill out the poll at the end of the webinar. Tell us what you liked, where we can improve, and what topics you'd like to see in the future. And if you are interested in CLEs, there is a CLE form linked in the materials page here. I'm going to keep posting this into the chat. That form, along with the PowerPoint for this webinar, is on that page. And as part of our responsibility to ensure attendance, we will provide a code word later in the program, and you must enter that word into the form. All right. We are very excited to have with us today Jacob Monty from Monty and Ramirez LLP. For over 2 decades, Jacob Monty has successfully practiced at the intersection of immigration, labor, and employment law. He is a nationally recognized authority on issues facing employers with large Hispanic workforces, and has written not 1, but 2 books on the topic, and speaks regularly in English and Spanish on navigating labor and employment matters in industries with heightened immigration scrutiny. His clients include professional baseball teams, grocery stores, restaurants, and construction companies, and he has represented employers throughout the Southern United States and in California, Illinois, and New York. Please welcome Jacob Monty.
Thank you, Audrey. Welcome. Excuse me. Let's get started. It's Halloween, and it is somewhat fitting because we have a lot of spooky news for employers on the immigration front. Let's go to the first slide, please. Audrey, am I going to have control of the slides, or are you? Okay.
I apologize. I was told that I was controlling your slides. Do you want to control them?
Perfect. Perfect. That's fine.
Okay.
So this slide is important because this identifies the 4 different types of interactions that can lead to an ICE encounter. And let's start with the first one. ICE audits, notices of intent to inspect I-9s. We are seeing so many audits right now, but because of the big, beautiful bill, This year, the ICE did about 3,000 audits. Next year, they're projecting to do 15,000 audits, and we're already in this next year because the government fiscal year began in October 1. So again, ICE audits are the most common type of interaction that is going to come the farmer or rancher's way. And I-9 audits are very prevalent, and they will get more prevalent as we get closer into the big, beautiful bill era. Second interaction, these are less common, but these are the ICE raids. This is where employees are arrested at the workplace. Raids are expensive to mount, but we have seen raids at agricultural employers this year. We've seen them at other times as well. So ICE raids, not as common, but certainly possible. And that's another type of interaction. The third one, targeted arrest. This is what we saw at the beginning of the year, at the beginning of the administration, where ICE was targeting aliens principally at their homes, but they were aliens with criminal backgrounds or prior deportation orders. And these targeted arrests were very common at the beginning of the year, but now they're less common because most of the people with criminal backgrounds or prior deportation orders have already been targeted, and now targeted arrests are less common. And then we added the fourth one, and this is traffic stops. This is what is driving a lot of the detentions right now. Traffic stops, driving while undocumented, DWU. This is what is causing a lot of aliens to have interactions with ICE. And this is the leading cause of arrests for immigrants. It is, some people might think, well, ICE, is ICE stopping people? Sometimes ICE, yes, is stopping people. But more common is local law enforcement is stopping the alien and then referring them to ICE or arresting them and taking them to ICE. We are seeing so much of this right now, and it is impacting employers because I dealt with an ag employer this week whose employees don't want to drive into town anymore to get fuel, to get groceries. They are just staying on the ranch, and which is not a bad scenario in the whole scheme of things, but it is impacting employers. So these are the types of ICE-related encounters. You all know that we are witnessing an unprecedented level of enforcement. The president promised this in the campaign, and he is certainly delivering. And one reason it hasn't gotten worse is there are limits on bed space. So, but those limits are going to be addressed with the big beautiful bill. So we will see a lot more immigration activity in this fiscal year. Let's go to the next slide, please. Well, the question always becomes, how do I get on, the ICE's radar screen? Did my name or did the ranch's name just get picked up? No, most of the time it is all tip-based leads. A dissatisfied employee, a general citizen who complains about all the workers congregating nearby, a innocent bystander victim of identity theft. We're going to talk about that, but right now our firm is handling about 10 I-9 audits, and 4 of them are the result of innocent bystander victims of identity theft. This is the scenario where somebody calls and says, hey, I've never been to Pennsylvania. I'm in Florida, and you're reporting revenue to my daughter's Social Security number. Can you help me? Oftentimes, those innocent bystander victims of identity theft get ignored. They never call them back. And as a result, that victim of identity theft goes and reports the employer to ICE, and they end up with a full-blown ICE investigation. So, yes, there are some random initiatives, but most of the ICE activity is the result of complaints. And it's important to understand that. And it is impacting employers because now employers need to be sensitive to complaints by U.S. workers, complaints by neighbors, because if you have a number of Hispanic workers, that there could be undocumented people there, and you could have some exposure. So it does put employers in a very tenuous position, almost that they're afraid of being reported. It is not a great environment for employers right now, to be sure. The bottom line, what I want to take you all to take away from this slide is, if you do get an innocent bystander victim of identity theft who says, "Hey, I've never worked in Pennsylvania, can you help me?" That's a great opportunity for you to jump on the situation, investigate. If the employee still works with you, interview them. You're going to have to terminate that employee if he admits that he's using the social of the innocent bystander, but you address the problem, get back to the innocent bystander. There's some IRS forms that need to be filed, TWC, WC3 form rather, and that needs to be filed. But once you do that, you've met your obligation, and the innocent bystander is less likely to go forward and complain to ICE. By the way, I'm going to mention a lot of things today. They're all contained in the Immigration Compliance Toolkit. I'll make sure that Audrey gets a copy of that so that she can share it with you all. We have inside the toolkit, we have explanations that describe the scenario of innocent bystander victims of identity theft and how to deal with that. Let's go to the next slide. Next slide, please.
And I'll just mention, I believe we do have that toolkit in PDF form. I'm going to put that on our website right now.
Great, thank you, Audrey. Okay, so I talked about the one big beautiful bill, and it's worth mentioning again because this is going to make what President Trump promised a reality. Because in the past there has been restraints, in budgetary restraints, but now ICE's budget has been injected with $170 billion for immigration and border enforcement. We have $45 billion for new detention centers. By the way, this is going to address the problem of inadequate bed space. I was talking with employers earlier this year, and they were saying, well, it's not that bad. We haven't seen the raids. That was because there was not enough bed space to detain people. As a country, we only have about 50,000 beds available for detention. Next year, which is actually this year, this fiscal year, we will have close to 100,000 beds, and that is going to mean the ability to arrest more people. So this big beautiful bill is going to be a good thing for ICE. It's going to be a bad thing for employers and immigrants. So it's important to understand that. Okay, let's go to the next slide, please. So we're not going to spend a lot of discussion on the H-2A visa program or even the H-2B visa program. These programs exist. They're cumbersome. The H-2A is for ag employers. The H-2B is for non-ag employers and sometimes quasi-ag employers. But the bottom line here is, we could go to the next slide. The new administration has also made legal immigration much more difficult. In the past, it was oftentimes people did not have to get interviewed if they had previously been issued a visa. Now we are seeing interviews being required more and more. And this is important to understand. even legal immigration is getting much harder under Trump too. So it is important for your planning purposes. In the past, if you've been able to send, to get your employees processed in Monterey or in El Salvador, and it's taken 2 to 3 weeks, look for more time and more delays, because interviews are going to be required more and more. This is part of their emphasis on making sure that people are vetted properly before they're admitted into the U.S. Let's go to the next slide. The H-2A program is great in a lot of ways. It is cumbersome, but the good thing is that it has no limits. The problem is that it typically has to be tied to the harvesting of a crop. So it doesn't work for all ag employers. By and large, it doesn't work for the dairy industry, for example. So it has some great features, but it does have some limitations that don't help all ag employers. We're going to talk in a few slides about some changes to the ag labor environment and some legislative proposals out there. But the H-2A program is a good program, but again, it has some limitations, and some employers have had to look at the H-2B program. The H-2B program is limited by caps, so it's not unrestricted like the H-2A program. So that's important for you to know. Let's go to the next slide, please. Next slide, please. Great. And this is a new final rule that went into effect regarding the H-2A program. And again, by and large, this is already settled. But again, new information on the H-2A program. Let's go to the next slide. I wanted to give you all some possible good news on this Halloween day. This Farm Workforce Modernization Act is a viable legislative idea out there. I heard from folks that were in Washington last week, and this bill is getting traction on both sides of the aisle. We are hearing that both sides of the aisle recognize that with regard to ag workers, something needs to be done. So there is a glimmer of hope here. And let's just keep watching for some good news on this front. But legislators love to hear from constituents, and chiming in favor of this bill would be important. You can see what it has in there: modernization of the H-2A program, making it less cumbersome, making it available for year-round jobs, for farm workers, a pathway to permanent legal status. And America understands the plight of the farm worker. So if immigration reform is going to happen countrywide, it's going to begin with the farm workers. And so keep your eye out on this. This is actually something that could happen next year, even in a country that is so divided politically. We are seeing some traction on this. So I just wanted to give you a bit of good news on this front. Let's go to the next slide. And back to bad news. Termination of TPS. Yes, we have been following the saga of TPS for Venezuelans, and by and large, the saga is over. The administration terminated TPS for Venezuelans, and this is after repeated challenges at the appellate level. The Supreme Court has said that the administration did have the authority to cancel TPS for Venezuelans. So this TPS, which was started by the Biden administration, has now been largely unwound. what it means for you all as employers is there were about 1 million people that had TPS or parole status from Venezuela, and they no longer have that status. So our industry was already facing a labor shortage, and it's only gotten worse. And this has meant that it's harder to find workers that have authority to work in the US. And what compounds the problem, and this is a good segue into the rest of it, is there are so many fake documents out there that employers don't know what a good document is, what a bad document is, and employers are hiring undocumented workers most of the times not knowing that they're undocumented because the documents are good fake documents. They look good, but in actuality, they're not good. All right, let's go to the next slide. And this kind of just sums up what happened with TPS. All right, let's go to the next slide and let's jump into I-9s. Folks, the I-9 law has been with us since 1986, and employers are continuing to mess up on it. And what are the mess ups we are seeing? Well, first off, some employers, some ag employers mistakenly, by the way, think, oh, it doesn't apply to the ag industry. That's wrong. It does apply to the ag industry. We represent a number of ag employers in the dairy industry, and you all are not only required to have the I-9, but ICE knows that the ag and the dairy industry have large numbers of Hispanic workers, and they frequently like to target the industry. So it's important to understand that the ag industry must complete an I-9 for every employee hired after 86. There's no small employer exception. This is another misconception. Many small employers think, well, I only have 10 employees. I don't need an I-9. Wrong. One thing to know about the I-9, it only applies to employees. So if you have legitimate independent contractors, you don't need an I-9. The I-9 now in 2025 is a one-page document. Essentially, it has 3 sections. Section 1, that's completed by the employee, and Section 2, which is completed by the employer, and then subpart B, which is completed by the employer when an employee's documents expire. But the form is appears simple, but it has been causing a lot of grief for employers for 40 years now, and this is not likely to go away anytime soon. If you want to avoid immigration fines, immigration criminal penalties, it all begins with the I-9. Section 1 should be left to the employee. You should not be responsible. You should not be writing on Section 1. But remember, you do have to ensure that the employee completes Section 1. Section 1, leave it to the employee, but you have to ensure that all of the sections are completed. Here's another point. I would rather you all not be translators or preparers under Section 1. Leave Section 1 to the employee. But remember, you have to ensure that it's completed. Some of the common errors we see on Section 1 is the employee won't sign it, or it doesn't designate which of the different categories belong to the worker, and that is a substantive violation. So Section 1 is very important. Let's jump to Section 2. Section 2 is where the employer's rep swears under penalty of perjury that he looked at documents showing the worker had proof to work in the US. And that's where the employer's rep would write down, if he looked at a list A document or a list B document or a list C document. Remember here, if you look at a list A document, you don't need to look at a B and C document. And here's where you would write down the identifying information on those documents. Again, yeah, the fines are it's possible to incur a substantial fine on the I-9 very quickly. The fines do add up. So again, if you want to avoid most of the problems you could ever face, you begin with the I-9. One scenario, what happens if I don't have an I-9? No problem. A late I-9 is better than no I-9. We have been helping employers all over the country go through and re-accomplish I-9s. I've had many cases where an employer was not fined, where we just re-accomplished the I-9. But here's the important thing. We didn't backdate the document. We acknowledged that we did not have I-9s, but we re-accomplished them as soon as we found out. And in that case, I've had a number of cases where ICE did not fine the employer because we showed good faith. Remember, the I-9 law has a strong good faith defense. So if you show good faith, you have a good chance of reducing or eliminating the possibility of fines. One big change that has happened in this area is, in the past, many lawyers, including me, used to recommend that employers would copy the documents the employee presented under Section 2. As a result of the aggressive actions we've seen by ICE this year, many employers and lawyers, including me, have now changed their advice and have said, hey, copying was never required. Do not copy documents anymore. If you've copied in the past, that's fine, but don't copy anymore. That is the big change that we've learned from 2025. Let's go to the next slide. Some other points is, I always get this question. Well, how do I know if it's a good document? Look, if the document looks good on its face and it looks like the person in front of you, you should accept the document. That assumes that there aren't misspellings on the document, that it looks like a genuine document. Remember, the law and the regulations make it very clear. You're not document experts. So if it appears genuine on its face, you should accept it. Later on, documents you should not accept, but you must complete. Oh, great question. Why am I recommending not to copy documents anymore? Great question. I'm doing that because in the past, copying showed good faith, and it was a good way to show that you were a good employer. Now we are seeing ICE use the documents that weren't required to be made in the first place against the employer, and they're saying, "Hey, employer, you should have been able to spot that in 2027 the I-551 permanent resident alien card changed, and it didn't look like the document that was submitted to you." And that type of rigor has never been applied in the I-9 context. We're seeing ICE apply it now. And to avoid that scenario, we're telling employers, complete the I-9 accurately, make sure you fill out all of the areas under Section 2, but do not copy the document, so that ICE will not be able to use documents that were not required in the first place against the employer. Great question. Let me reiterate, I'm not telling employers to shred documents that they've copied in the past. Just don't copy anymore, and then remove those copies from the I-9 files, keep them elsewhere, and that's what we're recommending. In the toolkit, we have a policy that outlines our reasoning and rationale for this policy change, and it lays everything out. But great question. Here's another issue that has come up in the ag area, the Spanish I-9. The Spanish I-9 is great, but it's not valid in the mainland. It's only good in Puerto Rico. So if you have Spanish I-9s, they're not acceptable. You're going to have to re-accomplish them. So that is something that has come up in the ag area a lot recently, and you will be fined for using the Spanish I-9. So just know that. The I-9, we do a 2-day course on the I-9. We're not going to be able to cover every scenario now. When I feel proud of myself. I remind everyone that I'm a subject matter expert in the I-9, and my wife kind of corrects me and says, Jacob, you're a subject matter expert on a one-page form. That's true, but this one-page form, it does have some nuances there. Spend some time looking at it. All of the fields should be completed. Remember, never backdate a document. Backdating is not good. It destroys good faith. You can reduce fines or eliminate them, but you need to show good faith. Yes, the Spanish I-9 has only been valid in Puerto Rico. It's never been valid in the US, and that has caused some confusion. But yeah, it's never been valid in the US. Great question. All right, let's go to the next slide. So you heard me say that this year, again, confusing, this year, which is 2025, January through September 30th of 2025, that was the first part of the government's fiscal year. We saw about 3,000 notices of inspection throughout the country. This next year, which we're in now, which began October 1, we're expected to see 15,000 notices of inspection being issued. And this is going to result in a number of fines, millions of dollars of fines, and this can cause a lot of confusion at the workplace. Why? Because most of the time, the notice of inspection is delivered by an ICE agent. So your employees may freak out and think, oh, a raid is happening, when in fact, the only thing that has happened is the ICE agent will hand deliver the I-9 notice of intent to inspect the I-9s to the farm or ranch. So it's important to understand that. Remember, you have 3 business days to respond to this. Don't feel like you have to assemble the I-9s immediately. You have 3 business days to respond to this notice. You should get a lawyer who knows what they're doing in this area to help you. Hiring a lawyer does not mean you're guilty. It means you're smart. We help employers all over the country with regard to I-9 audits. And again, this is not something you want to do on your own. And sometimes the ICE agents are a little tricky. They'll try to say, look, I don't want to have to come back, but if you want to, for convenience sake, do you want to just give me the I-9s now? And the answer to that invitation is no. You want to have a lawyer look at the I-9s with you before you submit them. One thing that is possible, depending on the senior agent in charge of where you are operating, the senior agent in charge of ICE, is sometimes you're able to make corrections to the I-9s before you submit them. And that can reduce or eliminate fines altogether. So that's one reason you want to have a lawyer help you with this I-9 audit process. Again, take advantage of the 3-day period. And let's go to the next slide, and we're going to talk about the timeline a little bit. So 3 days to hand over the I-9s. Then ICE will get back to you in about 30 days, and they'll say, look, we think these people are undocumented. We want you to re-verify their identity. And ultimately, they'll tell you you'll have to terminate them. And you're given a period of time to terminate them. Sometimes you can negotiate with ICE for additional time to terminate the employees, but be careful here. A lot of you all are recipients of crop insurance and other government benefits, and if you extend the time to terminate the employees that ICE identified as undocumented, you could be disbarred from doing business with the government, and that includes receiving farm benefits, farm insurance. So be careful. Sometimes the ICE agent might even offer, hey, we can give you an extension. We don't want to put you out of business. We don't want food to rot. And they offer that, but different parts of the government don't always communicate with one another. And I've had a number of instances where ICE has said, oh yeah, we don't want to put this farm out of business. you can have 3 months to terminate the employee, but nobody told the debarment office in DC about that. And then they were debarred from doing business with the government, and that includes, crop insurance and stuff. So you have to get counsel from a lawyer that practices in this area. I don't want you all to win the battle and be able to keep the undocumented workers for a period of time, and then inadvertently put yourself in a debarment situation. So let's go to the next slide. Okay. Plan ahead. You should go and test your I-9s before ICE does. Do a self-audit. You don't have to hire a lawyer to do it. You certainly can, but begin with a self-audit. Make sure you have an I-9 for every single employee that's on the payroll. Remember, you should purge I-9s after the retention date. Let's talk about the retention date. First off, all current employees, you always need an I-9 for them. Now, for former employees, you must retain the I-9 for 3 years from the date of hire or 1 year after the termination, whichever is longer. But remember, for current employees, you always need an I-9. Never throw away the I-9 for a current employee. And then for former employees, it's 3 years from the date of hire or 1 year after the termination, whichever is longer. Self-audits, you have 72 hours to assemble the I-9s. Let's talk about raids now. Let's shift and talk about raids. Raids are when employees are arrested at the premises. And this is where you need to put some thought into having a statement, a standard operating procedure. What are you going to do if this would happen? Are you going to demand a warrant? If you demand a warrant, is a administrative warrant sufficient, or should you ask for a judicial warrant? I'm going to tell you right now, employers in the ag industry need to demand a judicial warrant. This is imperative. Doesn't mean you're guilty. You're protecting your assets. You're protecting your employees. You're protecting, frankly, your liberty, your own liberty as an owner. So asking for a judicial warrant is not something that means you're a criminal. It means that you're insisting on your rights guaranteed by the Constitution, and it is important to do that. And you can do that in a non-argumentative way. You can say, look, officer, we want to comply, but I need to talk to my lawyer. He has indicated to me that we need to see a judicial warrant signed by a judge. Do you have one? Can I look at it? Can you send it to my lawyer? You need to push back. Pushing back does not make you a lawbreaker. You're enforcing your constitutional rights. Let's go to the next slide. Raids, again, they're not an everyday occurrence, but they do happen. And you do need to insist on a judicial warrant. You should try to involve counsel. You should try to keep notes of what is being taken during the raid. Oftentimes they're going to take computer information, I-9s, and keeping track of what they take is important. It is very disruptive and chaotic, but you do need to document what happened. Let's go to the next slide and let's see what really can happen when a raid goes awry. This is the Glass House raid in California that happened in July. Next slide, please. Brooke mentioned, this is again back on the I-9 audit area. The ICE is going to demand original I-9s. So you do have to give them originals, but it's imperative that you keep a copy of what you give them. You need to keep a copy of what you give them. They will require originals, but you need to keep copies of what you give them. Yes, we're going to show you. Great. Anita is asking. She would like to see a copy of a judicial warrant, and I think we have one in our in our next slides. But let's talk about this glass house farm rates. No, okay, first things, look, it was a cannabis farm. So, not your typical farm, but it was an agricultural employer. ICE argued that the triggering event was that ICE was looking at potential child labor, human trafficking abuses. And we see this scenario by ICE often. I saw it in Kansas about a month ago. They said, oh yeah, we targeted this restaurant because we had seen that they were sued by Department of Labor in the past for violating minimum wage laws, and we targeted them because of that. Point to be noted here, ICE does sometimes justify raiding employers when there are prior labor law violations. So that is true. On this raid in California, 361 undocumented employees were detained. 14 were unaccompanied minors, and the raid resulted in the death of one worker who was attempting to avoid detention, being apprehended, and he fell. So it was a tragic raid in that regard. Raids are chaotic. I have been involved in some of the largest raids in U.S. history. I was at the agri-processors raid in 2008 in Iowa, and we had helicopters all over. There were media. It was a very chaotic situation. Raids are chaotic. It's hard to keep your head about you during a raid, but you should absolutely maintain maintain calm and demand an I-9, a judicial warrant signed by a judge. Judicial warrants are hard to get, folks. Judges, even Republican judges, push back on what ICE asks for. They will ask, hey, well, why do you suspect that this employer is hiring undocumented workers? If ICE just says, well, it's an ag employer and we've seen Hispanics there, that's not going to be enough. Even hard Republican judges push back. They respect private property, and pushing back does not mean you're a lawbreaker. It means you're enforcing your rights. Let's go to the next slide. The Hundy ICE raid. It's not an ag raid, but again, 475 people detained. This was a case that now even the president is pushing back on this raid. He says that he now says he's not in favor of it. This was a situation where a number of the Korean workers had valid visas to work at the plant. They were being paid from the Korean parent, and they were doing some specialized work, and that is permissible work under the B1, B2 visa. But the ICE agents, didn't understand that. And now even the president is saying, hey, this raid maybe was not the best thing in terms of a lawful raid. And it certainly wasn't good for the Korean-US relationship. So let's go to the next slide. And here's the warrant issued in the Hyundai raid. And you see it's signed by a judge. Folks, this is important because a warrant signed by ICE is an administrative warrant, and that's not valid. You need to push back on that. Oftentimes, ICE will give you a warrant signed by a senior agent in charge. That is, again, those are called administrative warrants. Sometimes they're called Blackie's warrants after a case called Blackie's. But you can push back on an administrative warrant. You want a warrant signed by an Article 3 judge, and this is an example of one. And frankly, this is the hardest part I have with employers. They roll over too often, especially we represent a lot of hospitality employers, and they tend to be hospitable and they just want to be accommodating, and they roll over at times, most of the time, frankly, but they need to push back. Let's go to the next slide. We have okay. This is my slide on E-Verify. I need to cover this. So Todd Davis, the founder of LifeLock, ran these ads in big newspapers in the early 2000s saying, I feel so comfortable with LifeLock. I put my social security number out there and I guarantee that it won't get stolen. I was at a plant in Alabama in 2008 or 2009 actually, and we had two Todd Davises working at that plant. Neither one of them spoke English or Spanish. They spoke Guatemalan dialect. But what they had was a social security number that was valid. They were able, through the document vendors, to figure out when Todd Davis's birth date was, and they had fake documents made to show they were Todd Davis. They cleared E-Verify. E-Verify has a gaping hole in it, folks. Don't believe the lie that E-Verify is foolproof. There was a recent example of this in Nebraska. A meat packer was raided earlier this year, and he told the ICE agent, guys, I'm on E-Verify. What are you doing here? And the ICE agent responded, I mean, I have to give him credit rather honestly. He said, oh, E-Verify doesn't work. You know, he let the cat out of the bag. What many of us know, that E-Verify does not work. Oftentimes, ICE will try to negotiate with employers and say, look, you know, you're looking at $100,000 fine. I can lower it down to 30, but you have to get on E-Verify. Don't fall for that, folks. Being on E-Verify in the ag industry will make it very hard, if not impossible, for you to hire workers. Don't fall for that without understanding how difficult it will be to hire workers if you're on E-Verify. Identity theft is a real deal. We talked earlier about the innocent bystander victims of identity theft. Some of you ag employers that are large employers, and there are large ag employers, do have to deal with the ACA and error messages. We have a separate handout on that. You don't have to terminate employees with an error message, but you do have to raise it with them via the solicitation process. Let's go to the next slide. We're running out of time. This is the Hall of Shame. Again, a document needs to look good on its face. It shouldn't have a typo. It shouldn't have obvious signs of being fraudulent. If you turn over the document, it shouldn't say novelty item, two people in one photo. You have to be able to pass the 8th grader smell test. Would an 8th grader accept this document? Or would a bouncer accept this document? If the answer is no, you shouldn't either. But at the same time, if it does look genuine on its face and it looks like the person in front of you, you should accept it. Otherwise, you could be engaging in document abuse. Next slide, please. ICE and IRS are now sharing a lot more information than ever before. And this is something to be on the lookout for, especially for you large employers that have to deal with the ACA. Ignoring error messages is not a good thing anymore. So again, happy to talk to you all about error messages under the ACA. We talked about the 287G. Let's go to the next slide. Third-party notices that can trigger an audit. We talked about the Affordable Care Act. Again, this only applies to large employers. Really, you have to have more than 50 full-time employees. Not a lot of you all are going to be covered by the ACA, but if you are, you do know what an error message is, and you can't ignore them anymore. Let's go to the next slide. This is very important. So we've been talking about hiring undocumented workers and the penalties associated with that. Well, something much more severe than that is called harboring undocumented workers. And that means providing shelter, lodging, or any form of protection to someone who's in the US unlawfully. Now, how do you protect against a harboring charge? You do so by having an I-9 on every employee. If you have an I-9 on your employee and you complete it accurately, and you are not going to be subject to a harboring charge, because you're going to be able to show, hey, I did my best. The documents look good on their face. Where employers are vulnerable to a harboring charge is when they have no I-9s. And I'm going to share some examples with you. Let's actually jump to the Abby's Bakery slide. Let's jump right here. This is a tragic case. This is a bakery started by an immigrant couple. They're permanent residents. They had built this thriving business, a bakery that Immigration and Border Patrol used to go there all the time. They had 8 undocumented workers living adjacent to the bakery in a nice little apartment. The problem is they didn't have I-9s on those bakers. And then ICE was able to say, no, you were harboring the undocumented workers. Folks, the penalties for harboring start at $250,000. They're criminal penalties. The owners of this bakery were found guilty by a jury. They're awaiting sentencing. They will go to jail, all because they didn't have the I-9. They didn't understand the issue of harboring. Why am I mentioning this? I deal with ag employers all over the country, and they say, Jacob, we have workers living on our premises. And I understand that. And that can continue, provided you have I-9s for all of your employees. And we actually recommend something else, that you have a separate lease that documents that these workers who you have I-9s for are also tenants, and you have to charge them something. It's better to charge them something. It need not be a super high rate. You know, it could be something as small as $150 a month. But if you have a lease and you have I-9s, you can defeat a harboring exposure situation. This is very important for the ag industry. And I wanted to cover that. Let's go to the next slide. Yeah, so you need a formal lease agreement, and this is vital. Let's go to the next slide. Harboring has also found its way into non-ag employers. And again, this is a case out of San Diego. The employer was allowing workers to live at the premises. ICE sent a confidential informant to wear a wire to get the general manager on tape, admitting that while they did have I-9s for everyone, the general manager knew that they were not valid and that the workers were undocumented. And then because employees were living at the premises, they were able to charge the general manager, folks, not the company. They're going to charge the company later, but they went after the general manager, Washburn, and they charged him with harboring. And he ended up having that charge against him. So this shows how dangerous harboring can be. It also shows how sneaky or aggressive ICE can be. They will use confidential informants to make their case. And this is important for you as ag employers, that you have to act like you're being recorded at all times. There's no such thing as an employee who's trusted. You should act like you're being recorded at all times. You have to be careful when talking with employees. It's all right to be compassionate. It's all right to care about immigrants, but you have to avoid making admissions that you know that someone is undocumented, because if that employee is in a jam and he's facing deportation, he's going to pick his family over you, even though he's a long-term employee. So don't fall for that idea that, well, you know, Jose's a good employee, he would never do that. I have seen it happen many times where employees, because they're facing ICE prosecution, they will turn on employers and wear a wire. So very important. Again, Audrey has the toolkit.
We've got that linked on our the webpage for this event. So all this PowerPoint, that those resources are all available on the webpage. I think I'll just mention Attorney Jeff's comment here: one man's open field is another man's curtilage. That is
I love that.
there.
I love that. Yeah, I agree. Hopefully
See if
we
the
get the
PSP
right
works.
result in Pennsylvania for you guys.
Yeah, absolutely. We're waiting on an opinion any day here. So, well, Jacob, Monty, thank you so much for joining us today. This has been really great and really enlightening. Again, we've got all the materials up. And with that, I think we'll tell everyone good afternoon. Have a great weekend.
Thank you, everyone.
Excellent.
Go Lions.
Thank you so much. Bye.